There has been a ton of speculation surrounding the Idaho 4 case, predominantly because of how it was covered, how it was talked about, how it was investigated, and the amount of sealed documents that are in the court right now. But what if there was an indication? We knew how the court was going to lean towards a decision. Well, a commenter on one of my last videos brought this up and I was asked to make a video. And since this is a viewer-driven channel, that's exactly what we're going to talk about today. And if an open conversation is something you prefer, then this is the place for you. Welcome to the point, so let's talk about it.
Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use.
Now, in one of my previous videos, a commenter brought up that he noticed something within the judge's body language. And he asked me to make a video on it. And the idea that we could somehow predict what the court was going to decide is very intriguing. Now, of course, I am not a body language expert. But from everything I could read online, the general idea is if somebody is sitting down, whether it's in a relationship or a business meeting, and they are leaned forward, then that means they're engaged with what you're saying. They are interested in what you're saying. And to a degree, they agree with what you're saying. While if somebody is leaned back, that would generally indicate a disinterest or a disagreement. So is the judge agreeing and disagreeing right in front of our very eyes? Well, in these first two clips, you will hear both the state and the defense argue their positions on this grand jury indictment. So let's see if you see what I see.
Okay, Mr. Longston.
Here. I'm going to, I guess, be succinct since we argued almost the very same thing this morning.
Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals.
Now, as you saw, when the defense was speaking, the judge was leaned back. But while the state was making their argument, the judge was leaned forward. So is this an indicator of where he falls within this argument? Naturally, a couple clips by themselves aren't any type of indicator one way or the other. Well, let's look at this next clip. Now, the state is going to make the argument that if this appeal goes up to the Supreme Court, it stalls everything. And the court's going to lose their power to make decisions. And it's going to increase the amount of delays they're going to have.
And during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling.
Now, what I found interesting about that clip is you can see that the judge is leaned forward. So in theory, he would be engaged and in agreement to what the state is saying. But as the state makes the case that they're going to lose power and this is going to cause some sort of delay, he leans back. So are we seeing the judge agree with what the state says? But at the moment of delays and court losing power, he doesn't appreciate that. He's not okay with it, so he leans back in a defensive position. Now in this next clip, Jay Loxton's offering his rebuttal to what the state is saying in terms of the appeal. So let's see what the judge is doing here.
Mr. Longston. Why?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly.
Now, as we can see in that clip, he is leaned forward. So in theory, he is engaged to this. Now, one thing that is interesting, if you remember back to those original hearings over all this, the judge did say he thought it was an interesting argument. And he thought this was something that the Supreme Court may want to hear. So is this an indicator that he is interested or in some type of agreement with what Jay Loxton's saying? Now in these next couple clips, Bill Thompson is talking about what the state is trying to do here. And Ann Taylor is giving her perspective on where she believes the defense is falling within this scheduling order argument.
What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide.
Taylor?
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way.
And as we see, he has leaned forward with both of those. So we can't really tell for sure with both of these statements that he has any type of major disagreement with either of these parties. Now later on in the hearing, Ann Taylor makes a statement where she references the amount of work that the defense is having to deal with at this particular time and justifying her position as to why this trial can't happen in 2024. And let's see what the judge does here.
The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase.
So as she's mentioning the amount of documents she is having to go over, he goes from a lean forward position to a lean back position. So does everybody infer at that particular point he is interested in what she has to say, but he is not necessarily happy about the amount of evidence she is still having to go through? And of course he wants to hear from the state on this. He wants to know what is the state's reply to all these things that Ann Taylor is saying. And to summarize, Bill Thompson essentially says, yes, the defense has a lot of work. There's a lot of stuff going on. This is a very complex situation. And let's see what the judge is doing while Bill Thompson is talking.
Let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. You know, it's kind of like you ask one question, you get an answer, and that leads you to another question.
Now, as you can see while Bill Thompson is talking, he is leaned forward. So if what the body language experts are saying is true, then the judge agrees with what the state is saying. They are essentially agreeing that the defense has a whole lot of stuff to go through, and there's a very good possibility that there is a justifiable reason we can't have this trial in 2024. So when you look at all these clips put together, and I'll link the full video down below, are y'all seeing some type of indication on where the judge falls within these rulings? Is he leaning back more towards the defense or more towards the state? Is he strongly disagreeing with somebody or disagreeing with their point of view while not openly saying, I'm not interested, I'm going to disagree with this? It is really hard to say, because there were several clips where he was leaned forward with the state and the defense. And it may just be that this is an indication of his overall interest, if he's interested in a particular argument, rather than him having a bias or not. So looking at all this, I can't necessarily make a determination one way or the other. But what I can say from what I have seen, I have agreed with some of the stuff the judge has ruled on, and I've disagreed with some of the stuff the judge has ruled on. And a judge is supposed to be an unbiased person. He is supposed to call things straight down the middle for what is fair for both parties, so that a fair trial is had. So overall, it would seem to me at this particular point, if I can neither fully agree or disagree, that would mean that the judge is making rulings based off the law, which is all we can ask for. But the idea that we can get some sort of indication on his interest towards an argument is absolutely something worth talking about. And I would wonder from y'all if you've noticed the body language change during these arguments. And if that is an indicator to you how he may rule within these arguments. As always, if you see anything differently, you can let me know down in the comments below. Other than that, I appreciate your time. I appreciate you being here. Y'all stay safe, and I'll catch you in the next one.